Mr. Hitchcock.
Thank you very much, my lord. You won't be surprised to hear I was supposed to pick up where we left off,
Yes.
if I may. And that is Regulation 107B, which you'll recall is on page 162 of your first authority bundle.
Good.
Okay, thank you. Page 162 for 107B. Really, coming back to this question, whether the sole focus should be on the method that's been proposed by the taxpayer, or whether we should also consider the reliability of the standard method. And really, the obvious point I should have made this morning, and apologise for not having done so, is that the wording of the legislation does presuppose that the standard method first falls down. Because if you just go back to the language, picking up on the words, and that attribution differs substantially from one which represents the extent to which. It doesn't say better represents the extent to which, it says represents the extent to which. And what the draftsman's recognised there is that the method that's been employed, the standard method, does not represent the extent to which. So it's not saying, look, the only way to undermine the veracity of the standard method is by looking at the calculation. The draftsman, stage one, the standard method does not represent the extent to which. And then obviously we need an alternative method. We need to identify that to calculate the difference. But of course, this is where, and we'll come to the special method override legislation. There too, we need a method to calculate the difference to make the legislation work. But this trigger condition, there is the parallel, because differs substantially from one which represents, let's say, not better represents, but represents. And then this use of the words one which represents. The question then is whether, in applying the substantially criterion, we are confined to the proposed solution, the better methodology that's been identified by the taxpayer, or whether we can look more broadly. Well, again, we say look more broadly. That's certainly not ruled out by the word one which. There may be several contenders, and again, that will draw a more closer analogy with the approach adopted in the context of the special method override. Just in that context as well, just finishing that submission, to pick up on a point made to me this morning by Lady Justice Whipple, well, what about the directive? Have you arrived now, Mr. Hitchmo, at a non-EU compliant construction? And the answer to that's no, because if you go back to the directive, this is, well, 173 starts on page 8, but over the page on page 9 is the permission to derogate in 1732. Member States make the following measure, and then C, authorise or require the taxable person to make deduction on the basis of use. So again, it doesn't say that better reflects use. It's presupposing, again, that this rough and ready calculation that we have may be an unreliable proxy. So don't worry, Member State, you can instead insist on use.
But the standard method is a use-based method.
Well, it's a rough and ready, several. It's a rough and ready proxy for use that may fall down.
They're all proxies for use.
Yes, they're all proxies.
It is the standard method of attributing residual input tax on the basis of use. I'm not sure you've got the authorities here, but I think that's absolutely home and dry.
Yeah. I'm not.
It's just all right.
Yeah, but when we translate that into 107B, that attribution differs substantially from one which represents the extent to which. There's a recognition there by the draftsman that the standard method has first fallen down.
And isn't C not use, but use made of all or part?
Yeah, it's C in the directive now,
Yeah.
my lady. Yeah.
Rather than it being just use, it's you're able to require the taxable person to use a deduction on the basis of use made by for all or part.
Yeah. Yeah. Great. And that approach to the legislation, reading the legislation in that way, we say, well, there are two additional reasons that support such construction of the legislation. The first is the way in which the special method override legislation has been construed and applied. And the second, it better reflects the approach generally applicable in all VAT appeals, where the approach generally is to identify the correct amount of VAT, the amount of VAT either payable or repayable. I'll take authority to make that proposition good. But let me turn first, please, to the special method override legislation. Take you to it already. It's in Regulation 102A and B. Can I take you back to 102A, please, which is on page 138. And you'll see it applies in circumstances where the taxpayer is calculating the deductible portion of the residual input tax using a special method. And that method does not fairly and reasonably represent the extent to which goods or services are used by him or are to be used by him in making taxable supplies. So yes, it's another use-based calculation, but it's a calculation that's fallen down. The commissioners may serve on him a notice to that effect, setting out the reasons, what are the problems with the method that's been employed. And where they do that, the consequence of being served with a notice, the consequence of the regulation applies, are identical to the consequences of the standard method override applying. The taxpayer is told to calculate the difference. We see that from Regulation 102B. And the point here is that the question whether the legislation applies, the trigger condition and the consequences of it applying, how it applies, are then separate issues. And the reasons that the revenue have to give for serving the override notice, what they see as the problem with the method, is not confined to the solution to that problem, the means of solving the problem. Yes, my lady.
Is this a one-way notification process?
No.
Then? So is it only the commissioners who can say to a taxpayer,
no,
your method doesn't work, or is there another way that the taxpayer can turn around and say my special method's not working?
Yeah, there's another. I should have taken to page 140, Regulation 102C.
Got it. Okay.
The taxpayer can request the service of a notice.
May serve on the commissioners a notice.
Asking for a notice.
Okay. Yep.
So the two-way aspect comes in through a further bit of legislation. But again, the solution in either case is left to the taxpayer to come up with the alternative calculation. And of course, if the revenue don't like the result, they don't like what the taxpayer's done, they can assess. But there again, the assessment's going to be based on a calculation. So we're littered with calculations. But the real point is the question whether there's a problem with the existing method and the adequacy or otherwise of the proposed solution, we see are discrete issues. And were that not clear from the legislation itself, the point is made in plain terms by Mr. Justice McComb in his judgment in a case called Vision Express, which you've got behind tab 10 in that same bundle, page 270. Now, in this case, Vision Express, the revenue had served a special method override notice on a taxpayer that operated a chain of opticians stores. And that they also assessed the taxpayer for tax that was said to be due by applying an alternative proxy that they claimed better reflected the economic use of the taxpayer's stores. The tribunal dismissed an appeal by the taxpayer against both the override notice and the assessment, and the taxpayer appealed to the High Court. High Court as it was in those days, the old tribunal system. And can I ask you to turn, please, to paragraph 48 of Mr. Justice McComb's judgment, which is page 288. And here we'll see Mr. Justice McComb rejects an argument that had been advanced by Mr. Cordara on behalf of the taxpayer that the validity of an override notice was predicated upon the revenue having identified an alternative proxy for use that was more fair and reasonable. So, 48. In the result, I find that the tribunal made no error of law in dismissing the EUK's appeal against the override notice. In my judgment, this follows from the conclusion that the statutory criteria for the service of the notice was satisfied. Once it was found that the special method did not fairly and reasonably represent the extent to which goods or services are used by a taxable person in making taxable supplies, it followed that the notice was valid and the appeal had to be dismissed. I cannot agree with Mr. Cordara in his submission that it's necessary at this stage of the process to examine the methodology adopted by the commissioners in raising their assessment in order to find whether the cure is worse than the disease, as Mr. Cordara puts it. The sole issue on the appeal against the notice is whether Regulation 102A is satisfied. If it is satisfied, that's the end of the matter, and the notice is good. It is, as a matter of statutory construction of the regulations, unnecessary for these purposes to decide whether the commissioners, in calculating their later assessment, have come up with an alternative which does satisfy the overall statutory objective of a fair and reasonable attribution. And if you then drop down to 52, the judge says, I now turn to the appeal against the assessment. And so he acknowledges again there that the issue whether the override applies and the consequence of applying, the need to identify a use-based calculation, they're separate questions. It's a two-stage analysis that's called for. And we would submit there's no principled reason why a different approach should be taken in a case such as the present, where it's the standard method override as opposed to the special method override that in issue. In each case, we're faced with an existing method that produces a result which doesn't reflect the economic use by the taxpayer of its VAT-bearing overheads, with the consequence that in each case, the taxpayer shall come up with a calculation, an alternative calculation, that does. Now, just for completeness, can I also take you, please, to what Mr. Justice McComb then had to say about the appeal against the assessment? We see
just pause, sorry again,
yeah.
I'm just losing my bearings a bit. So this is a case where you've got a notice, because it's
Yep.
a special method
Yep.
override notice.
Yep.
There's no notice arrangements on the standard
Nope.
method override. And accompanying the notice, you've got an assessment. So this is the second bit of what we're looking at now, which is the validity of the assessment.
Yep.
You're going to take us through that.
Because
we don't have an assessment in our case.
No, because what you have here, the taxpayer's been served with an override notice, and the taxpayer then says, well, actually, I think what we're doing at the minute is all fine, thank you very much, we don't need to do anything else. So the commissioners say, well, yes, you do. That's why we served with the notice in the first place, so here's an assessment.
Yep.
So that's why there's a difference.
Yeah.
But the point you make about, well, in this case, there was the notice, and there's no notice requirement with the standard method override. Well, you're right. There is no notice requirement with the standard method override. But the trigger condition for the service of the notice is the same as the trigger condition for the application of the standard method override. That trigger condition being the existing method, the method that's being employed, is no longer a fair and reasonable proxy for the use of VAT-bearing overheads. It's the point I made immediately after lunch. It's reflected in the language of 107B as much as in the language of 102A.
I mean, the language is obviously different.
Yeah, there's no notice requirement.
Well, leaving aside the notice requirement, for 107B, it differs substantially from one which represents the extent, blah, blah, blah.
Yeah.
The other one is does not fairly and reasonably represent the extent.
Yeah.
So one is sort of abstract, and the other is referring to a difference.
Well, in the case of the standard method before the override applies, there's a threshold that needs to be crossed. This idea of substantial, not present in the case of the special method override legislation. Absolutely right. But in each case, we are dealing with a method that, for whatever reason, is no longer a reliable proxy. And in the case of the special method override, that in and of itself, is sufficient to for the taxpayer to have to employ some different calculation. That in and of itself is not sufficient in the case of the standard method override. We also have this substantial criteria to grapple with. But the trick condition in each case is the same. It's the point I've made. The standard method override legislation applies where that attribution under the standard method differs substantially from one which represents the extent to which, it being recognised there that it no longer does that. It doesn't do that. And that is the same as the trigger condition we see in Regulation 102B. Now, going back to the Vision Express case, if I may, which you had open behind tab 10 of your authorities bundle, we were at page 288, where Mr. Justice McComb explained that the trigger conditions for the application of the legislation and the consequences of it applying were separate matters, and then he went on in 52 to deal with the appeal against the assessment. And in paragraphs 53 to 55, he goes on to explain it's a long passage to read. I won't get you to read it now, but he goes on to explain that the tribunal then is not faced with the binary choice of accepting or rejecting the Commission's assessment. What it's really concerned with is the basis of that assessment, the reliability of the calculation, the override calculation that the Commissioners have now employed through the assessment machinery. There's one further case that I'd like to take you to, please, that relates to this special method override, and that's the decision of the FTT in the case of St John's College, Oxford. That's in your second authority bundle, behind tab 11, page 291. And can I ask you to turn straight to page 314, please? And you'll see there the heading, Our Jurisdiction in Relation to the SMON, the Special Method Override, from Regulation 102B.
I'm so sorry, it was page 300 and...
314, madam.
Thank you very much.
Paragraph 83, where the tribunal's dealing, as it says, with its jurisdiction in relation to the Special Method Override and Regulation 102.
Paragraph 283. Did you say, what was the paragraph?
Paragraph 83, my
83,
lady. And can I invite you to read 83 to 85, please?
Yeah.
So there too, the tribunal recognises that the reason why the existing method may no longer be reliable, and the solution to that problem, that raised discrete issues. And we'd emphasise what the tribunal says in paragraph 85, and it says, in an appeal against tax due or input tax repayable, the tribunal must therefore determine the figures on the basis of an appropriate attribution. So, in other words, if the trigger condition for the application of the override is satisfied, in other words, there's a problem with the existing method, the identification of a solution to that problem ultimately falls within the jurisdiction of the tribunal.
Can I just understand how it works?
Yeah.
So you're using a method.
Yeah.
The revenue will assume don't like it.
Yeah.
They serve the notice saying, no, that's no good. And probably they assess you at the same time using some method of their choosing.
May or may
not
not. The taxpayer may say, okay, I'll put that method aside. We need to come up with something else. Here it is. This is what we've done. And the revenue then still may not like that and may assess.
Yes,
So it isn't just you've been served with a notice and the taxpayer says, oh, we're going to continue business as usual. It may not be that.
Yes, I see. I mean, even if the revenue then make an assessment on the basis of a particular approach, it's open to the taxpayer to say, no, that's the wrong approach.
Yeah. Yeah. And this idea that it's ultimately for the tribunal, it's within the jurisdiction of the tribunal to come up with, or to identify the basis for an appropriate attribution, again emphasising the same word that the tribunal did there in paragraph 85 of its decision. The Upper Tribunal rejects that, revisits that point in paragraph 147 of its decision on page 327.
I'm sorry, we're at page 327
Page 327 of the same case, my lady,
Okay.
St John's.
This is First Tier Tribunal, isn't it?
Sorry, did I say upper?
You said
Yeah.
upper, which is why I thought it would be
I'm
somewhere
very
else.
sorry,
Right.
my lady.
Mr. Hellier, I'm sure,
Yeah, it's a
used to
decision
sit
of
in the
Judge
Upper
Hellier.
Tribunal too.
Yeah, it's a decision of Judge Hellier in the FTT. I do apologise.
So we're going to paragraph
Paragraph
147.
147 of that same decision, page 327 of your bundle, where the tribunal says Regulation 102C requires a complete revisiting of the input tax calculated on the basis of use. The voluntary disclosure of March 2004 purported to be a calculation of the basis of use. The appeal against the refusal by HMRC to accept that disclosure is, in our view, an appeal within Section 83C in relation to the amount of any input tax which may be credited to any person. In determining such an appeal, it seems to us that the tribunal must determine the amount which should be credited. And the approach that Judge Hellier adopts there is for the tribunal to identify an amount of tax due. Of course, that reflects the approach that we've seen adopted by Mr. Justice McComb in the Vision Express case when he turned to consider the assessments in that case. So in circumstances where the tribunal concludes that an override calculation is required, that the trigger condition has been satisfied, the identification of an alternative proxy to reflect the use by the taxpayer of its VAT-bearing overheads ultimately falls within the jurisdiction of the tribunal. And let me turn with that in mind to my second point, is that really should cause no concern because it reflects the approach that's generally adopted, or that generally applicable in all VAT appeals, that the FTT should consider whether there's been an underpayment or overpayment of VAT. And if it's satisfied that there has been, it shouldn't dismiss an appeal merely because it disagrees with the way in which the underpayment or overpayment has been calculated. And to make good that proposition, can I take you please to the decision of the Upper Tribunal, this time to the Upper Tribunal, in General Motors, which is behind tab 16 in the same bundle, page 455. And you'll see it was an Upper Tribunal consisting of Mr. Justice Henderson, as he then was, and Judge Sinfield. And the case involved a claim by General Motors for the repayment of VAT said to have been overpaid on the self-supply of certain cars. The facts aren't really material. But can I ask you to turn straight to paragraph 66, please, on page 469. And can I invite you to read 66 through to 70, please?
Yeah.
So you'll see, as the Upper Tribunal explained, it was the tribunal's duty to apply its expertise as a specialist tribunal to ascertain the true amount of VAT due. And that might involve the tribunal performing its own calculations, stating the principles by reference to which an appropriate calculation could be made. But that's precisely the approach that we've seen adopted in the special method override cases that I've taken you to. Now, just before turning to see what the Upper Tribunal had to make of those submissions, why it rejected them, there are just two further authorities I should deal with up front, because on a superficial reading, both may appear to provide some support for the proposition that the FTT in an appeal of this nature enjoys a more limited jurisdiction, the more limited jurisdiction we've seen set out by the Upper Tribunal in its decision here. And it's important that I explain up front why those authorities do no such thing. The first, keep coming back to it, the judgment of Mr. Justice Warren in St. Helens School, Authorities Bundle 1, tab 8, page 227. As you'll remember, in that case, the school was applying to use a special method that HMRC had rejected. And in the course of his judgment, Mr. Justice Warren considered the jurisdiction of the FTT in a case of that nature. And can I take you to what he had to say, please? It's page 236. The heading there, the appellate's jurisdiction. Now, in paragraph 26, Mr. Justice Warren explained that the jurisdiction of the tribunal in an appeal against the refusal by HMRC to approve the use of a PESM was appellate, it wasn't supervisory. And historically, there had been some doubt about that, given that Regulation 2 says that HMRC may approve the use of a PESM. So he deals with that point. He said, no, tribunal nevertheless has an appellate jurisdiction. But it's 27 that we're interested in. Because in 27, he then went on to consider in more detail the nature of that jurisdiction. And he says, this is not to say that the tribunal is able to put forward its own version of a more reasonable method. If there is one, it can't do so, as the tribunal recognised in para 43 of its decision. Accordingly, a tribunal can substitute its own view for that of customs in deciding whether the proposed special method is fair and reasonable. If on an appeal by a taxable person from a refusal of customs to allow a proposed special method, the tribunal decides that the method is fair and reasonable, and also that it's more fair and reasonable than the method in operation, be it the standard method or some other special method, the appeal should be allowed. But if the tribunal thinks that both the existing method and the proposed method are unfair or unreasonable, it could not allow the appeal, even if it considers that the proposed special method is less unfair and unreasonable than the existing method. And the point I need to deal with there is His Lordship's observation that the tribunal can't put forward its own version of a more reasonable method. And there are two short reasons why the same approach can't be adopted where either the standard method or special method override legislation is in play. The first is that the legislation has a different focus. And I say different focus because unlike the override legislation, the use of a special method doesn't depend on a prior finding that the standard method is unreliable. And it follows from that that an appeal relating to the use of a special method can succeed, even if the result produced by the standard method is itself fair and reasonable. The question is merely whether the result produced by the special method is more fair and reasonable. The second reason why the observations of Mr. Justice Warren should be confined to cases concerned with the use of a special method is that the application of a special method is, of course, discretionary. Taxpayers are under no obligation to request one. Commissioners are under no obligation to direct the use of one. But the application of the override legislation, on the other hand, is mandatory, as we've seen. And I've already taken you to the two further passages, paragraphs 82 and 83 of His Lordship's judgment, where he actually goes on to consider the standard method override. I won't take you back to what we looked at this morning. That's page 250. The second authority I should deal with up front is another decision of the Upper Tribunal, this case, the time in a case called Temple Finance, which is in your second authority bundle, tab 18, page 521. Judge Sinfield again, this time sitting with Judge Falk, as she then was. Bit of context, Temple sold goods on credit, and it recovered the input tax on its overhead costs by applying the standard method. The revenue in that case argued that an override calculation was needed because they claimed the standard method attributed too much of the taxpayer's residual input tax to its taxable supplies. It was a bit like VWFS, similar issue. And in short, the revenue said that the value of Temple's taxable supplies should be excluded from the turnover-based calculation. And the FTT disagreed. The revenue appealed to the Upper Tribunal. And one of the grounds of the revenue's appeal in this case was that the FTT had adopted the wrong approach when considering the application of the override. And that's the point we're interested in. If I can ask you to turn to page 543, page 539, please. And if I can ask you to read paras 59 to 61, please. And the point I need to address here is the observation in 60, of course, where the Upper Tribunal says the FTT is not required to make its own inquiry. Now, the important point to bear in mind about Temple Finance is that, conceptually, it was quite a simple case. The sole issue was whether the inclusion of taxable sales in the turnover-based calculation overstated Temple's taxable use of the overheads, its overhead expenditure. And if so, as the revenue contended, that could be corrected by a single simple adjustment excluding the value of those taxable supplies from the turnover-based calculation. But if not, if there wasn't anything in that criticism, as Temple contended, because no other criticism of the standard method had been identified, well, no other adjustment was required. Which is why, in paragraph 61, the Upper Tribunal said that rejection of the revenue's criticisms, they said, effectively left the default standard method as the applicable method. So really what they're saying, it wasn't incumbent on the First Tier Tribunal to go looking for problems if they hadn't been identified by the parties themselves. Absolutely. But the case before you, the case before the Upper Tribunal here and the FTT is rather more complex. Because, as I'll go on to explain when I develop our third ground of appeal, this isn't a case like Temple, in which the appellant relies on its override calculation as the grounds for arguing that the standard method failed in its objective, no longer represented a fair and reasonable attribution. The override calculation, the floor space-based override calculation, is relied on as a solution to that problem. Not a solution to a problem, but not as evidence in the problem itself. So, unlike Temple, this isn't a case in which the alleged problem and the alleged solution march hand in hand. Now, of course, the Upper Tribunal did say in paragraph 60 the FTT wasn't required to make its own inquiry as to whether there might be another method that was more preferable. And in the context of Temple, the context of that case, that was clearly right. Because the override legislation can't apply unless the standard method is shown to be an unreliable proxy. It wasn't for the tribunal to identify problems that hadn't been identified by the parties themselves. And viewed in that context, the Upper Tribunal's observation that the FTT wasn't required to make its own inquiry makes perfect sense. But we say it would be wrong to extrapolate from what the Upper Tribunal had to say in that paragraph. A rule that the First Tier Tribunal should never make its own inquiry as to whether another method may be more preferable. And certainly not that it would be wrong of the tribunal to do so in circumstances where other evidence before it established that the trigger condition, the reliability of the standard method, had been undermined. That would be a step too far, as we say. Now, with those submissions in mind, can I then please turn to the analysis of the Upper Tribunal, where it considered the question of its jurisdiction. We call that core bundle tab 7 of the Upper Tribunal decision. And can I ask you to turn to paragraph 122, please, on page 100. So, you know, first of all, in 121, there's a reference to Vision Express and St. John's that I've taken you to. But then in 122, the Upper Tribunal says, here the tribunal is concerned with an altogether different question as to whether the SMO contended for guarantees a more precise determination of the deductible proportion of the input VAT than that arising from the application of the turnover-based method. The SMO must be able to guarantee a more precise result than the result which would arise from the application of the turnover-based method. Now, the problem, we say, with that paragraph is that the Upper Tribunal fails to grapple with the way in which it should approach the question it's identified in the first place. It fails to grapple with the approach it should adopt in order to identify whether the override legislation is engaged in the first place. And there appears to be an assumption, or perhaps assertion, that it should do so wearing judicial blinkers, if you will, looking only at the override calculation that's been relied on before it. Yet that was the very issue that we've seen Mr. Justice McComb considered in Vision Express, albeit in the context of the special method override. And the Upper Tribunal here, it fails to engage, it singularly fails to engage with that aspect of his Lordship's judgment. And we contend, contrary to what the Upper Tribunal says here, it wasn't concerned with an altogether different question. It was wrong to say that. The central point made by Mr. Justice McComb in his judgment is that one mustn't judge whether there's a problem with an existing method by focusing on the proposed solution to that problem. As he put it, the question is not whether the cure is worse than the disease. And yet we say that's precisely the approach adopted by the Upper Tribunal in this case. If I can look next at paragraph 123, please. They say that the standard method is the default method based on the value of supplies, and by definition will provide a fair and reasonable deduction based on the use of or intended use of purchases. Permission isn't needed to use it. Regulation 107B2 expressly requires that the taxable person shall calculate the difference and to account for the amount so calculated where an attribution has been made under the standard method, and that attribution differs substantially from one which represents the extent to which the goods or services are used or to be used in making taxable supplies. It's therefore for the taxpayer to displace the standard method. So what the tribunal is saying there is, because in circumstances where the override applies, the onus is on the taxpayer to calculate the difference, it's for the taxpayer to prove that the override applies in the first place. It's for the taxpayer to displace the standard method, the tribunal says. And the problem with that, well, first, as Temple Finance illustrates, circumstances will arise where HMRC are the party looking to apply the override, displace the standard method. And because in that case, in Temple, the taxpayer had failed to calculate the difference, contending there was nothing wrong with the standard method, the revenue had then assessed. So, first problem with 123, the tribunal fails to recognise that HMRC may want this override legislation to apply. They may be relying on it. Second, we say the ability for HMRC to rely on the need for an override calculation, as well as the taxpayer, is perfectly compatible with a fair reading of the legislation and more closely accords with its purpose. Its purpose being to come up with a solution where there's a problem with the standard method. And the third difficulty with this paragraph is that even if, contrary to what I've said so far, it is for the taxpayer to displace the standard method, the Upper Tribunal still hasn't explained or grappled with the vexed question how the taxpayer is meant to do that. This question, whether in considering whether there's a problem with the standard method, is the jurisdiction of the tribunal confined to an analysis of the proposed solution to what has been perceived as a problem. And on that, you already have my submissions.
I mean, taking out of your order probably, what do you say the Upper Tribunal should have done?
What the Upper Tribunal should have done, and this we'll deal with this when we get to third ground of appeal, what it should have done is to say, well, we put the space-based calculation to one side. We've rejected that. Let's assume they could do that. They should then have said, look, is there other evidence before us relied on by either party that undermines the reliability of the standard method as a reliable proxy?
But even so, even if they find such evidence, they can't do anything further without finding that there's something that differs substantially.
Well,
and so what were they supposed to do? Had they got evidence showing that there was another method that would differ substantially?
Yeah. So they say, is there other evidence that establishes a problem? Now let's consider that evidence, because does that evidence in and of itself enable us to answer the substantial question? Does that evidence, or can that evidence in and of itself be used as the foundation for a method? And if the tribunal had considered that question here, then the answer it should have come up with was yes. And again, this is the ground we cover in our ground for appeal number 3. So is there a problem? Yes. Let's look at the evidence that establishes the problem. Does it give us the basis of a solution? And the tribunal at that stage should be exploring the solution with the parties. A bit like the special method override cases we've looked at. That's precisely what Judge Hellier envisaged in his decision in St John's, and indeed Mr Justice McComb in Vision Express, where he went on to consider the assessment, the validity of the assessment. And it's also compatible, got my submission, compatible with the approach more generally applicable in VAT appeals, determining the correct amount of VAT due. So that's what we say it should have done. So that's 123. 124, you'll see, it says, the tribunal says it agrees with Temple Finance. Well, you already have my submissions on Temple Finance. I dealt with it up front. And in 125, they say they accept a submission that Mr Donwell had advanced, that the jurisdiction of the tribunal in cases where the application of the override legislation was an issue mirrored the tribunal's jurisdiction in a case where the Commission had refused use of a special method. It's the St Helens school point, and again, you already have my submissions on that. And then 126, we see the conclusion, which I've taken you to already. So just drawing our submissions on jurisdiction together, we contend that the Upper Tribunal's analysis and conclusion, when it turned to consider its jurisdiction, were flawed, and that the override legislation envisages a 2-stage process. First, investigate whether there's a problem with the standard method. And in approaching that question, the tribunal should consider all the evidence available to it. And second, in circumstances where the tribunal concludes that there is a problem, it should then go on to consider the solution to that problem. But at that stage in its analysis, its jurisdiction isn't confined to merely approving or rejecting any solutions being elected by the parties. That's why we say it wasn't a complete answer to the case, that the FTT had rejected the floor space-based calculation. Which brings me then squarely to our third ground of appeal. As I mentioned, we deal with this at paragraphs 49 and 57 of our skeleton argument. And we say that had the Upper Tribunal not erred in its approach to the question of jurisdiction, it should have concluded that the evidence before it established that the standard method was no longer a reliable proxy and that the override legislation applied. And I should be able to deal with this ground relatively quickly. Let me start, please, with the amount of input tax that the appellant was able to recover by applying the standard method. And the easiest place to find that is the decision of the FTT. There's a helpful table, para 99, this is page 174. So if you've got that table, it sets out the amount of the appellant's overhead in various years together with the sum recoverable under the standard method. And I've done the maths. It results in a recovery percentage of between 17 and 12%. So 17 in 2012-13 down to 12 in the final year, 17-18. So that rate of 12% in 2017-18, the standard method then assumed that 88% of the appellant's overhead VAT was being used economically to make exempt supplies of gaming. Yet in that same year, the evidence before the tribunal was that 1/3 of customers visiting the Hippodrome had no interest at all in gaming. They didn't gamble. They only made use of the taxable facilities on offer. If I can just show you the FTT's finding to that effect, please. Para 61 of its decision on page 167. Invite you to have a look at that finding, please, para 61. And that evidence, that reference to 1/3, 33%, is a strong indication that 1/3 of the appellant's overhead VAT, as a bare minimum, should be recoverable. And I say as a bare minimum because, of course, there's also some use of the taxable facilities to make taxable supplies to people who've also gambled in the Hippodrome. But just let me stick with that figure of 1/3 for the moment and go back to that table, paragraph 99. That's the table on page 174. And just sticking with that last year, 2017-18. 1/3 of the total overhead VAT figure, the 1.8 million odd figure, 1/3 of that figure is 601,000 odd, £601,271.56 to be precise.
Where's the figure again?
It's £601,271.56p. And the difference between that figure and the £216,457.76 recoverable under the standard method, you see that figure, recoverable under SM. So the difference between that figure and the sum recoverable under the standard method is, again, I've done the maths, £384,813.80p. And that difference is, of course, substantial within the meaning given to that term in Regulation 107C. Nevertheless, the Upper Tribunal cast doubt upon the reliability of that figure, the 1/3 figure, as a guide to the economic use of the appellant's overhead costs. And can I take you back to the Upper Tribunal's decision, please, to see why, see what it had to say? Can I ask you to turn to page 128, please? We pick up at para 193 of the decision, please, which is at the top of that page, where they say that even if the burden had been on HMRC to satisfy us that the standard turnover method guarantees a more precise determination of the deductible proportion of the input VAT than the floor space SMO proposed by HCL, we would have been so satisfied. So here you'll see, having rejected the appellant's floor space based apportionment as a reliable proxy, which in view of its conclusion on jurisdiction was essentially the end of the matter, the Upper Tribunal nevertheless went on to explain why, in its view, the standard method was in any event a more reliable proxy. And in that context, can I ask you to look at 195, please? There's only one sentence we're interested in here, where the 1/3 figure was considered. It's just below the first whole punch. We have found that a third of customers. You've got that sentence. We have found that a third of customers do not gamble, and that is a physical proxy for the economic use. But it's not a good proxy for economic use when gambling customers are spending considerably more. Floor space or customer numbers do not more fairly reflect economic use. And with respect, and this is our third ground of appeal, with respect, we say the reason given by the Upper Tribunal for rejecting customer numbers as a guide to economic use is wrong. And we say that for two reasons. First, the logic of what the Upper Tribunal says here, that the standard method is a better proxy because gaming customers spend more. Well, that assumes an inevitable correlation between economic use and turnover. In other words, it's the same logic that underpins the standard method itself. And the flaw in that logic is that if it were correct, circumstances in which the override could apply, well, they just wouldn't arise. The second point is this. The Upper Tribunal, in any event, made further specific findings which support not only the application of the override legislation, but also the conclusion that the amount of its residual input tax, which the appellant should be able to recover, should be no lower than 1/3. Can I take you to one final passage in the Upper Tribunal's decision, please? It's page 1, para 191 on page 127. And in this passage, the Upper Tribunal was considering what it termed general areas within the premises of corridors, cloakrooms, toilets, staff rooms, and the like. But can I just take you to 191 little d, please, where it says, therefore, the evidence in respect of these general areas, 37% of the whole, was that 33% was used only for taxable business. Yet, the Upper Tribunal nevertheless concludes that a mere 12 to 17% of the associated input tax is recoverable. We've seen that from the table in the FTT's decision. And with respect, we say that conclusion is wrong. So in the form of the data relating to customer numbers, as well as this finding here in relation to unallocated floor space, 33% used only for taxable business. There was ample evidence before the Upper Tribunal which should have led to the conclusion that an override calculation was required. That leaves one final question. What that calculation might look like on the assumption that the Upper Tribunal was entitled to set aside the FTT's decision and the floor space-based allocation.
I mean, just to be clear,
Yeah.
on your case so far,
Yeah.
we would either have to make the decision ourselves or send it back to somebody else.
Yes. Yeah. Yeah. You would either have to make the decision yourself or remit. That's where we get to. Yeah.
Yeah.
Because FTT, we never got here. They preferred the floor space-based apportionment. Upper Tribunal said no, and effectively, the standard method applies by default. And we're saying, well, that was wrong. The standard method doesn't apply by default in circumstances where it's flawed. And you've got to test its veracity and then say, well, what would an alternative calculation look like? And that's where we are. And it's the first time we're there. But you're right, Michael. Yeah, it does. I'm afraid the task falls to you or you remit.
And to be clear, if we get to that point, what do you say we should do?
Well, I would say you should be able to make that decision yourself on, well, the final submission I'm going to make is to that effect.
Yes, I see. I mean, just picking up one point that passes through my mind. When we're told that a third of customers don't do something,
Yeah.
do we have any evidence as to how long different customers spend there? I mean, suppose your 1/3 of customers each came in for 5 minutes, and the 70% of customers came in for 24 hours each. How would that play out?
Yeah. Yeah. Look, it's a fair point, my lord, but we've got to say, well, what is it they're doing in there? And the pure taxable customers, they're either come to watch a show, and the residency for some time now has been something called Magic Mike Live, which is not, as I thought, karaoke. It's a stage show. So that's the current residency. So if you're going to watch a show, you're in there for a couple of hours. You probably have a drink. If you're going to have a meal, well, probably a couple of hours and a drink. And if you're out for a night of drinking, well, again, it's going to be more than 5 minutes. So I'm giving evidence, but
Well, that's what I'm just thinking. Is there any evidence?
no, there isn't. No. Well, there's no evidence on what are called dwell time.
Yes.
Which I think is what you've got in mind.
Because the idea of a footfall use-based method, which
Yeah.
you do come across a fair bit,
Yeah.
don't you, is that whoever goes into the place, roughly speaking, spends the same,
Yeah.
goes there for sort of the same reason and spends the same amount of time there.
Yeah.
I can't think of a good example now, but a shop might be a good
Yeah.
example where, whether you buy taxable or exempt items or zero rate or whatever, it would all come out in the wash. But I suppose that's what my Lord's question is driving at, is if you were going to do a footfall analysis, you'd need to know a lot more about the sort of people that you were looking at in each cohort, because drawing on ordinary common sense and knowledge, you might think that that the average time of a non-gambler at the Hippodrome is, you might think, I don't know, we need some evidence to tell us, might be less than the average time by a gambler.
Well, the short answer to that, my lady, is we don't know, and it's the point that my lord
They're going for
Justice
very
Newey
different purposes,
put
that's
to
the
me.
point, isn't it?
Yeah. We don't. We've got no evidence on dwell time. The evidence we do have is on purpose, why they go there, and we know what the taxable activity within the building is: bars, theatre, and restaurant.
Yeah,
And I can quite see, if you're going to the theatre, you're likely to stay longer. If you're popping in for a drink, having just seen what the Hippodrome is, you might not be there for such a lengthy period.
Or you may love it.
Or you may love it.
Which you can't prejudge. You may love it and say, well, actually, it's my new local.
Yeah.
But yeah, we don't know. And look, if you come to the conclusion, if we get here and you come to the conclusion that dwell time is an important consideration, well, you don't have the evidence, and the only option in those circumstances would be a remitter. I accept that.
And more than that, on that thesis, if dwell time mattered, it wouldn't just be a remitter on the existing evidence. You'd have to have new evidence.
Well, we don't have any evidence in dwell time.
No.
Look, I mean, if we were simply concerned with the existing evidence, if we had the evidence here, I'd be saying to you, let's get on with
Yes.
it. Let's not waste time going back to the FTT.
How does this all going to work? I sort of fear that we're going to be stuck in an eternal loop, because let's just say that we're entirely with you. We think that footfall is a good way of doing it, but we need to know more. I think we've agreed between us that we probably would need to know a lot more. How do we do it? We remit it to the First Tier Tribunal, do we, for a sort of rehearing, effectively? For FTT, you were right to say that the proposed area-based method didn't give rise to a fair and reasonable result, and we are satisfied there's something a bit wrong with the standard method, so we're not going to use that as a default. But we think there might be something in the footfall method. Could you have a look at that?
Yeah, well, it would be a remitter, obviously, with guidance. The floor space is off the table. That's gone. Yeah, let's assume that's the conclusion you reach. You reject my submission. Floor space is off the table. So let's have a look at the standard method. We can see that there are problems with it, and on the face of it, the result it produces, there's a substantial error, significant, whatever the word was. So you say there's something in footfall, but actually, for us to get comfortable with footfall, we would need to be satisfied that the customers all entered the premises for round about the same amount of time. The dwell time was broadly consistent. So that may be where you go. But giving pointers on what you consider the material evidence, the evidence that would go to corroborate or undermine that 1/3 figure, would look like.
Yeah, it's very open-ended, isn't it? I mean, isn't there one answer? I just put this out there. That if we felt that there was something in the footfall, it's the right thing for us not to do, to say, well, Hippodrome, you've had your opportunity on an appeal, and in fact you've put forward a method that we don't agree with, so we're going to dismiss the appeal because the point on the appeal has no merit. But by the way, we think there might be something in an alternative that was likely discussed, and maybe that's the one to look at for the future. But then you start again in the tribunal with a fresh proposal, and then the issues, I suppose, you've lost the years in between. But that's sort of where it goes.
Well, we've lost the years in between, but the other point, my lady, is to get there. You would have to reject my submissions on jurisdiction. Well, you have my submissions on jurisdiction. Why that would be?
Yeah. I've got those submissions.
Yeah. But of course, it's not simply a question of saying, well, have another go. To arrive at that conclusion, the submissions on jurisdiction would have to go.
I'm concerned about the kind of directions that we would have to give to the FTT in the circumstances we're putting forwards, in the sense that we'd have to say, wouldn't we? Yes, we think we've cleared away floor space. We're unhappy with standard method. We think there may be something in footfall, and then we would have to give them quite clear guidelines about and how would we be in a position to do so in relation to footfall dependent on. We wouldn't just be able to say dependent on dwell time. It would have to be a more sophisticated proposal than that, I would have thought, in order to assist them. And if we were to do that, how would we evaluate those other bells and whistles?
Well, with respect, my lady, I mean, you talk about sophistication. Let's wind back to that guidance we looked at this morning in Volkswagen, that we're looking for precision but not perfection. And in giving that guidance, you shouldn't say, what sort of guidance would we need to give to arrive at the perfect attribution or the perfect solution? There's always going to, well, these things are, it's a proxy.
So you think that would be enough? We would be able to give direction that they should consider footfall by reference to dwell time, for example, and that would be sufficient.
Insofar as you say, well, we think dwell time is really important, that footfall takes us part way there, but it doesn't take us all the way there. What's the missing link? And the missing link we've been debating is dwell time, and that's a relatively easy question to ask and answer. We're not talking about a...
And then it would be proposed, would it, that the FTT is seized with this, asks the questions, the parties go away and find evidence and bring it back? Is this...
Well, if you handed down a judgment saying we think dwell time is important in addition to into footfall, then in the first instance it would be for the Hippodrome, the appellant, to produce some evidence of dwell time for the revenue to consider and accept or reject as the case may be. And then obviously if they rejected that evidence, then we would end up back before the FTT. But it would be a hearing of fact. There would be little if any prospect of a further appeal. I mean, it's unlikely there would be a Wednesbury challenge or Edwards and Bairstow challenge. So it would be a short factual question for the FTT insofar as the parties were able to reach agreement in the light of your guidance on the veracity of the evidence. But these sort of issues, whenever we have a remitter, this sort of issue arises. But we know that it is a possibility that is ordered.
Can I look at these same matters in a different context?
Yeah.
So you appeal the assessments or whatever here, and you say, we've got this other method. You don't at that stage say to the revenue, please revenue, consider not merely the method we're putting forward, but every other possible method. The revenue is not presumably on notice that you think that a method of coupling footfall and dwell time is an appropriate method. No evidence is put before the First Tier Tribunal as to dwell time. So the First Tier Tribunal could not, or could it, have adopted a footfall stroke dwell time method?
I think you need to look at the way in which the Hippodrome put its case in the FTT, because it's always been the Hippodrome's case that you have to start with the question whether the standard method is a reliable proxy and then move on. And in developing
but
that...
someone somewhere in this tribunal court system has to come up with an alternative method.
Yeah.
So did you put before the First Tier Tribunal or the Upper Tribunal with appropriate notice to the revenue of the sorts of things that might be required evidentially to deal with the question, an alternative approach that could have been adopted by the First Tier Tribunal or the Upper Tribunal?
The 1/3 figure has been relied on throughout to undermine, we would say, the veracity of the standard method as a reliable proxy. Now, nothing more, because then say, well, having put the standard method to one side, here's what we say an appropriate calculation looks like. But the 1/3 figure, I mean, that's why there is that finding in the FTT's decision that the 1/3 figure was being used in that way. Was the submission made to the FTT, look, run with this as an alternative proxy? No, it wasn't. And there was no need, because of course the FTT
decided to feel favourable.
Yeah, absolutely.
Yeah.
And you'll be aware, I don't know if I need to take you to it, but in our skeleton, we do come up with a method that is then based on that 1/3 figure.
Yes.
For your note, it's at paragraphs 54 to 56, but you
I seem to remember some formula.
Yeah. Well, yeah. It's 1/3 with then a turnover based tweak.
Yes, I see. Yeah.
So, my lord, unless I can assist you further, you might have our submissions on the first 3 grounds of appeal, and so I'm going to hand over to Mr. McGee, who's going to deal with the short technical point.
Yep. Thank you very much.
Thank you.
Mr. McGee.
My lords, my lady, this is ground 4, which is dealt with at paragraphs 58 to 68 of our skeleton. And it's a point which in the current case arises only if the appellant is unsuccessful on ground 1 and in relation to the capital goods scheme items, i.e. the cost of the refurbishment, etc., rather than the ongoing expenses, particularly rent. For the first point, that's because the revenue except the appellant's override calculation adequately deals with the use to provide business entertainment, and that's recorded by the UT at paragraph 29 for your note. If, however, you accept our jurisdiction case and we ended up with a calculation such as the method formula we've just been discussing, we would then need to look at business entertainment because there's no adjustment made in that calculation for it. So it would arise in those circumstances too. And for the second point as to why it's only on the capital goods scheme items, that's simply because for business entertainment and the capital goods scheme, it was dealt with in a single decision letter that was appealed together. Whereas in relation to the ongoing items, there were separate assessments made at a later date, and the appeals against those were stayed behind these current appeals. And that's recorded by the revenue at footnote 9 of their skeleton. And the point fundamentally is about the business entertainment block, which I'll show you in a second, and fundamentally whether you apply this at the beginning of the process, and then apply the partial exemption calculations to the result as the revenue say, or whether, as the appellant says, you apply the partial exemption calculations first, and only then apply the block to anything that is left that's needed to be blocked. And we say that applying the calculations first and then the block is both the approach prescribed by the legislation and B, avoids any double restriction. Briefly on the structure of my submissions. First, I'll deal with the legislation, which really is also our positive case on this, because as we say, that's fundamentally where the answer is. Second, what the Upper Tribunal say about this, and why we say that's wrong as a matter of authority. Third, the revenues case on this. In relation to the revenues case, I should briefly note that my learned friend has very helpfully indicated that the Crown don't maintain their case on EU law in relation to the business entertainment block. That's the arguments of paragraphs 45 and 46 of their skeleton, that whatever the technical arguments which HCL raises in respect of the domestic legislation, our arguments must be wrong as a matter of EU law.
Oh, sorry, let me just identify that. There's paragraphs
45 to 46 of their skeleton argument. Yeah. At page 45, hopefully. And if I might then start with the legislation. That's at tab 3 of the authorities bundle, and you've already gone to some of this already with my learned friend. But just to remind you of the definition of input tax at page 92 of the authorities bundle, which is that it's the VAT on the supply to him of any goods or services, being in each case goods or services used or to be used for the purpose of any business carried on or to be carried on by him. That's 24 sub 1. 24 sub 2.
I'm sorry, which page was it?
Sorry, 92 of the authorities bundle.
I'm very grateful, thank you. Yes.
Sub 2 gives a definition of output tax. And then sub 5 and also sub 6e, but I think I can make my submission solely in relation to sub 5, make provision about a different scenario to the one that we're in. And that's a scenario where a taxpayer purchases services and goods, etc., partly for the use of their business and partly for other purposes. And the effect of those provisions is to prevent a portion of the VAT on the supply to him of those goods or services from being input tax. And there's no submission that these provisions apply here, and the regulations that are made under the power in sub 6e are not the input tax block that we're concerned with.
No, but if you had I can't remember, I'm reaching back into my memory, but if you have a business, non-business, a non-business-business split, you do that first, don't you? You take out the input tax that's attributable to non-business activity, take that out of the pool first.
Exactly.
Then you apply your...
You have the sort of the Lennox option of taking the whole thing in first and then suffering an output tax charge on your private use. You can do it either way. That
Lennox plays with the sort of starting position, as I recall it, is that if you've incurred input tax, which is attributable to things outside the business altogether, you work out what that is to start with, and you take that away, you take that off the table.
Precisely, it's not input tax if it's being used not for the purposes of your business, and that's made quite clear, in fact, by 24(5)(a). So that's a deeming where a relevant asset held for the purposes of a business carried on or to be carried on by a taxable person is not to be regarded as used for those purposes if and to the extent that it is used for private use or private use of the person's staff. So maybe it's a slightly different point, but it's the same fundamental provision that you don't have input tax, or to that extent you don't have input tax if it's business, non-business. And there are certainly similarities between the two concepts, but we would say that fundamentally the legislation takes a very different approach to the ordering with the two concepts, because in one case it is input tax which falls to be blocked, and in the other case it's not input tax to start off with. And when we come to the case of Thorn EMI, that's going to be a relevant analogy that's drawn in the cases. Then 25(2), again very briefly, that's on page 95. And that was the provision that gives you a credit for the amount that you get under section 26. And then you get to deduct that from any output tax you put in. But 25(2) starts with subject to the provisions of this section. And that's the critical point for us. Because if we then turn to section 25.7, which is at the bottom of that page and onto the following one, we get what is the power, or rather it's the successor to the power that was used in creating the input tax block, and it is the current vires for that block. And there the Treasury may by order provide, in relation to such supplies, acquisitions, etc., as the order may specify, that VAT charged on them is to be excluded from any credit under this section. And skipping over A, but just briefly to set the context for another submission, B, such an order may contain provision for consequential relief from output tax. And pausing there, we say it's critical that what it says is it excludes it from the credit, so that you first have the credit and then you're excluded from it, rather than saying, like the non-business situation, that it's not input tax to go into calculating your credit at all. Section 26, which perhaps to some degree is logically prior, and I'm not going to take you to it, it's on the following page, is the one that tells you where you go to get your partial exemption calculations, and those are the ones at Part 14, etc. Turning, however, to the order itself, which is at tab 2, page 16, I might invite the court to read sub 1, sub 2, and sub 3 to itself.
Sorry, I wasn't keeping up.
Sorry, 25, sorry, not 25. Article 5,
Yes.
1 to 3.
1 to 3, yeah.
So I get the idea of 1. What's 2 doing? It's saying if you on-sell business entertainment,
I
at a
think
profit,
so,
you're going to have to pay tax on it.
or perhaps if you, because there's a to be used for the purposes of any business entertainment in sub 1, you might also get it where you then change your mind, perhaps. So you might be restricted under 25.1, but then in fact still sell on a, say you buy a bottle of champagne to give away for the purposes of your business, and then circumstances change. You wouldn't have got the credit under sub 1 because you were to be used for the purposes of making business entertainment. But then in fact you sold it. And what 25.2 does is it only imposes a VAT charge on the excess.
So it's if you sell it for profit.
So it's only if you sell it for profit. And the 3 points I'd like to make briefly are, 1, that in sub 3, business entertainment is by definition entertainment provided in connection with a business carried on by him. Secondly...
Sorry, hang on.
Sorry.
Yep.
It is by definition in connection with a business carried on by the taxable person. Secondly, to repeat the point made in relation to the language of 25, that it excludes from credit under section 25 rather than expressly puts it at any earlier stage. And thirdly, that the Article 5 sub 2 only is engaged where Article 5.1 has precluded the deduction of the input tax. It's where by reason of the operation of paragraph 1 above.
Does that mean that when you entertain somebody with your bottle of champagne, if you did use it for business entertainment, you wouldn't have to pay any output tax on it?
Yes. If you give it away for business entertainment.
If you open it and drink it, or if you give it, or if you sell it at the price you got it for, that's all neutral.
So long as all of that, yes. I think there might be a slight difficulty if you drank it yourself because it then might be private use. But
that would be a good complication. We could spend hours on.
But I'm very glad that doesn't arise in the present case.
Yeah.
And fundamentally, what we say is legislation is clear. It tells you that it's input tax. It tells you that you put it through Article 14 and, Part 14 of the VAT Regulations and the calculations there. And then you check it against the other provisions of Section 25.2, which includes 25.7 and this input tax block, and you don't get a deduction in relation to it. And that's a straightforward set of tests to apply. And in the case of a purely taxable business, obviously it's quite easy. You can follow all those steps very easily. And in the case of a purely exempt business, it's also quite easy because the answer is going to be nothing. You don't get anything out of it anyway, so it doesn't really matter what order you do it in. It's in the case of a partly exempt business that the question arises. And there, the fundamental point is that the standard method, or whatever method has already been used, has only allowed through the amount of your inputs, or your residual inputs, which are attributable to taxable supplies. And therefore, if it's not got through that, or rather, if it's attributable to making exempt supplies, it won't have got through the standard method calculations by the very premise of those calculations. And so what's left to restrict is only a portion of the business entertainment if it is used for both business entertainment for taxable business and for exempt business.
Can we just have that sentence again?
Yes.
So what's left to restrict?
What's left to restrict where you've applied the standard method or another method, and by that hypothesis have removed the extent to which these inputs have been used to provide to support the exempt supplies made by the business.
Sorry.
Yeah.
By that hypothesis, have removed
the extent of the residual input tax that has been used to make exempt supplies you are left then in relation to the business entertainment with only a subset of it that needs to be restricted if it is used for both your taxable business and your exempt business.
I thought, sorry, I've got a bit lost.
Yeah.
We have to go over that again. I thought where we were was if you're using a standard method,
Yep.
you directly, you've already taken out any input tax used to support exempt supplies by direct attribution. And
Yes.
You've also taken out, haven't you, the residual input tax that is attributable to exempt supplies because you've applied your percentage.
Yes.
So you've got a percentage left.
So you're left with a
might be,
percentage. And
which
that
is notionally or residual input tax that is a portion or attributable to the taxable parts of your mixed business.
precisely.
And that shouldn't have any business entertainment input tax in it, should it? Because we know that we're not allowed any of that.
But no, it should still have some business entertainment input tax in it. Because that comes at the later stage, it's then removed from that credit before you actually get it. Let me put that again.
I'm going to have to work out if I've got a pot of entertainment tax, 100.
Yup.
Am I going to have to work out how much of that I think is attributable to the taxable supplies as a sort of mini working of the standard method?
Precisely. But it doesn't. We're not told to use the standard method, so it's a straightforward commercial apportionment. In the same way as if you had a business, non-business apportionment in the first place.
But it's residual input tax, but it was directly attributable, wouldn't we be in a different territory?
Yes.
There isn't any attribution, it's just a question of how
But there can still be an
proxy
apportionment of it, my lady.
But you say there should be a different proxy used when it comes to business entertainment from the heated debate that's already taken place on what proxy to use for all the rest of the residual tax in the bucket. You've now got a different sub-bucket for this, have you?
Effectively, that we have findings from the FTT as to the use of the business entertainment in this case, which is that it is predominantly to support the exempt business. And so our case is that only the amount that is not in that predominant bucket or sub-bucket is the amount that falls to be restricted now. So say predominantly equals 90%. It's only that 10% that's left that needs to be removed at this stage. No, sorry. Yes, that's precisely right.
But why? I mean, why? Is it just because it suits you better that way? Because the legislation
It's because the legislation tells us the order in which to do it.
Okay, well, I haven't quite got that. You'll have to help me.
Because it tells us that, first of all, in section 25(2), that you're entitled to the credit you get from the proportions put in under section 26. And that's the part 14 of the VAT regulations, with, first of all, the removal of first of all, the apportionment of directly attributable taxable and exempt supplies, and then the carve up of the residual input tax under the standard method. And then you take that result from part 14, as you were told to you in section 26, and you plug it into section 25 sub 2. But because section 25(2) tells you that's subject to the provisions of this section, you then check it against the other provisions of section 25 before you actually get your credit, before you deduct it from the amount of any output tax that's due from you.
I would have thought the natural meaning of Article 5 is that you don't do any of that, because what that tells you to do is exclude from any credit under Section 25 any tax incurred on business entertainment.
But you don't have a credit under Section 25 until you've done your partial exemption calculations.
Okay, I don't understand.
It's only once you've done your Section 26 calculations under Part 14 that you have
Part 14. What's Part 14?
Sorry, Part 14 of the VAT regulations. That's got Reg 101 in, but it's also got Regulation 102 and 107B.
Okay, so the VAT regs.
Yeah,
okay,
sorry.
So can you just give me the sequence that you say
Of
again?
course. So, Section 25 1, you account for and pay VAT in relation to accounting periods. Section 25 2, you're entitled at the end of each accounting period to a credit of so much of your output tax, of his input tax as is allowable under Section 26. That Section 26, if the court might turn to page 97, tells you in Section 26(1) that the amount of input tax to which a taxable person is entitled to credit shall be so much of the input tax as is allowable by or under regulations as being attributable to supplies within subsection 2. The relevant supplies within subsection 2 are the supplies made are the taxable supplies, and subsection 3 says that the commissioners shall make regulations for securing a fair and reasonable attribution of input tax to supplies within subsection 2, and then various other things that regulations may provide for. Those regulations are in Part 14 of the VAT regulations, starting at page 117 of the Authorities Bundle, tab 4, and include in particular Regulation 101 at page 127. And Regulation 101 tells you that you start off with, go through 101 in slightly more detail. Regulation 101.1 tells you your provisional deduction shall be the amount that you get out of this calculation. This is page 127. And first of all, under 101.2, you identify the goods or services supplied to the taxable person in the period. That's 1012A. 1012B then says that the directly attributable to taxable supplies inputs should we put on one side, should we put in the taxable pot. Then 1012C tells you that no part used exclusively in making exempt supplies or in doing anything other than taxable supplies shall be attributable to taxable supplies. So you put it in bucket 2, the exempt bucket. And then 1012D and all the other niceties of that then tell you what to do with your residual input tax. And so once you have gone through the provisions of Part 14 of the VAT Regulations, you will get an amount of input tax which you are entitled to deduct provisionally, because that's what you do at the end of each accounting period. And then you can take that amount of input tax and plug it into section 25 sub 2 on page 95 of the bundle. But before you deduct it from any output tax that is due from you, it is subject to the provisions of the section of section 25. And one of the provisions of section 25 is section 25 sub 7, which is the ability for the Treasury to order that in relation to such supplies as the order may specify, the VAT charged on those supplies is to be excluded from any credit under the section. And one of the ways in which the Treasury has exercised that power is the input tax order at tab 2, page 16, and article 5 thereof, whereby if you get goods or services to be used for the purposes of business entertainment, they are to be, the tax charged on those goods or services is to be excluded from any credit under section 25. So you have your credit, first of all, from the application of section 26 and the VAT regulations, and then you have to exclude from your credit what you're told to exclude by article 5 here. And so what the input tax order does is to preclude the recovery of otherwise allowable input VAT.
Doesn't this make it worse for you, not better? Because if you follow it through logically like that, you'll get your pot at the end, your percentage that you might otherwise have got back, against which you have to deduct the whole of your business entertainment back. Because I can't see how in Article 5 you can say to yourself, well, I'm only going to knock off the bit.
Because the part of your... We're dealing all of our cases about the residual input VAT. We're not dealing with anything that's been directly attributable.
Yeah, but that,
so it's
with respect, that's not what Article 5 says. Article 5 says you're not allowed any of it, full stop.
Ah, well, there's a case on whether or not you can have any of it, where you make... If you have a supply that is used both for the purposes of business entertainment and for making taxable supplies, you can have the relevant proportion. So that's the case of Thorn EMI that I'll come to, where fundamentally they had chalets constructed to be at air shows, and they had nice times for their clients who came along and drank champagne.
Should we just leave it? Let's get to Thorn EMI is a really difficult case, so let's get there in a minute. And I'm sorry I distracted you. Ignore my question. Let's get back to your sequence. So I've got as far as if goods or services are used for the purposes of business entertainment, they're excluded from any credit, and that was under
Article 5.
Yeah, but it's what? It's Article 20, Section 25(7). You say that
25(7) creates the power, indeed.
Yep. Okay.
And we say that the only tax that is that is left after the application of 25(2) and 26 and Regulation 101 of the VAT regulations is the amount of the input tax that related to our taxable supplies. And so the only amount of input tax restriction that is left is the amount of our business entertainment that related to our taxable supplies. Because the amount to which our residual input VAT was used to provide business entertainment for the purposes of our exempt business has already been removed by the application of the standard method. Because what the standard method has done is to identify the extent to which this input VAT has been used to support our taxable business. And that's, I'm going to use the words directly or indirectly, and I don't know whether they're going to be helpful, but I'm going to try it briefly. That's either whether it's directly for exempt supplies, or through the slightly indirect measure of using business entertainment to support exempt supplies. Both of those elements have been removed by the application of the standard method, because what it does is to remove anything that relates to your exempt business when it works. And so what you're then left with is a subset of your input VAT, some proportion of which was used to provide business entertainment for your taxable business. And that's what Article 5.1 is used to carve out.
And what's the figure that Article 5 tells you to carve out of your residual pot that you would otherwise be able, the percentage of your residual tax that you would otherwise be able to set against your output tax? What does, on your case, does Article 5.1, what figure are you getting at?
It doesn't give us a direct figure. That's then a question for a commercial apportionment. And in our case, it's going to be pretty small because we have the finding of fact that I'm going to turn to, that the predominant use of our business entertainment was to support our exempt business. And so therefore, by the hypothesis of the standard method, has already been removed.
So all we are looking at is the bit of residual input tax. Okay, is the bit that supported our taxable business, yeah?
Yeah.
Because inevitably the rest will come out at the top of this funnel as a result of the application of the standard method.
Yes, possibly at the middle of the funnel, but certainly higher up the funnel.
Higher up the funnel.
Top of the funnel is perhaps the business, non-business, but...
Yeah. Okay. And the bit that supported our taxable business is, you say, for you to apportion on a commercial basis, depending on how much entertainment is given to support the different bits of your business.
Precisely.
But why is it residual if that's so? Why isn't it just directly attributable?
Because we're starting off with a... we're starting off with a single invoice for our rent.
This is input tax on business. It's nothing to do with rent. This is input tax on business entertainment.
My lady, this is precisely to do with rent. The revenue are seeking to apply a restriction to our rent. Well, not our rent, but the capital goods. So when we were building the Hippodrome, which obviously is to be used for the purposes of our whole business. And the Crown's case is there has to be a restriction on that input VAT to reflect the extent to which the Hippodrome as a building was used to provide business entertainment. So it's not about a bottle of champagne, but rather about the building in which the bottle of champagne is given away. So that's why we end up in quite such...
Okay.
And if I might then turn to how the tribunals below had dealt with this and show you the finding of fact that I say is key. The FTT didn't need to deal with this point, perhaps to their gratitude, because of their conclusions on the suitability of the standard method and the HCL's partial exemption calculation. And for your note, that's at paragraph 130 in tab 11 of the core bundle at page 178, where the tribunal records that they didn't need to make a decision on this point. The FTT did, however, make a critical finding of fact at paragraph 60, which is at page 167 of the bundle.
Hold on a minute, going a bit fast.
Sorry.
So again, so you go from 130 to where do you want us to go next?
So paragraph 130 was the fact they didn't need to decide it.
Yeah.
And then paragraph 60, which is at page 167.
That is bottle of champagne related.
Indeed. But the restriction that the revenue is seeking to apply is in relation to the building in which that was given away.
Being stupid, I haven't focused on this before properly. So we give away 1.2 million out of 7.2 million hospitality. What does that mean?
That the £1.2 million worth of free food and drink is given away in relation to a year.
And what's the 7.2 million hospitality? I know.
I think that must be the 7.2 million must be the total amount received by the hospitality business.
Turnover.
Yes.
I see. Yes. Yeah, that makes sense.
But the finding of fact that I'm focusing on is they are predominantly gaming customers.
Yes.
But complimentary food and drink may also be given to, for example, restaurant customers on their birthday.
Yes.
Whereas the issue did arise before the Upper Tribunal. And you've already gone to the Upper Tribunal, set out the legislation at paragraph 12 and paragraph 13. These are the provisions of the VAT Act at pages 88 to 89 of the bundle. So the full bundle.
Mm-hmm.
Excuse me?
Yes.
Yeah, sorry. Mm-hmm. And the end of paragraph 13, the Upper Tribunal said that credit, i.e. the credit you get out under section 26, can be restricted by regulations made under section 25 sub 7 to provide that input tax of certain kinds is not deductible. For example, such as that relating to business entertainment. We say that bit's precisely right, that it's a restriction of an existing credit rather than going in at the calculation of the credit stage. And the Upper Tribunal then returns to the issue at the end of its decision, at page 128 of the bundle, where it comes under the heading the CGS issue. And at paragraph 198 to 200, it sets out the background. At 201, it sets out the relevant bit of the order that we've already looked at. And then at 202, it describes the issue. We don't quite agree with the Upper Tribunal's description of the issue. How we would put it is that it's whether the block is to be applied first or after the standard method, so as only to restrict the use of the inputs to provide business entertainment that furthers the taxable business.
So whether the block is to be applied first or
after the standard method.
So keep going.
So as only to restrict the use of the inputs to provide business entertainment that furthers the taxable business.
Sorry. So it's only to restrict use of inputs
to provide business entertainment that furthers the taxable business. Given that the use to further the exempt business has already been excluded by the standard method. And similarly at 203, our case is that it's not under the standard method alone, but rather under the standard method followed by the business entertainment block. Which the Upper Tribunal then records accurately at 204 to 206. Core of its reasoning, however, is then found in the last two sentences of paragraph 207 at the bottom of page 129 and the beginning of page 130. Statutory apportionment of input tax under Regulation 101 sub 2 is as between input tax used for taxable supplies and input tax used for exempt supplies. However, input tax used for gratuitous business entertainment is neither. And that last sentence, first of all, contains within it a tension. Because if the input tax used for gratuitous business entertainment is neither used for making taxable or exempt supplies, how is it used for the purpose of any business carried on by the taxpayer? And if it isn't used for any business carried on by the taxpayer, it can't fall within the definition of input tax at section 24 sub 1. So to say it is input tax is to say it is used for the purpose of the taxable person's business. And secondly, it is simply not correct, with respect to the Upper Tribunal, that input tax used for gratuitous business entertainment is neither used for making taxable or exempt supplies.
Sorry, say that one again.
Simply not correct
Yes.
that input tax used for gratuitous business entertainment is neither used for making taxable or exempt supplies. And that proposition, that it's not correct, or rather the reverse proposition that it may be used for taxable or exempt or both, is made good by the Associated Newspapers case. And that's at tab 17 of the second authorities bundle, at page 490. It's a case about the VAT treatment of various types of vouchers given away in the Daily Mail and the Mail on Sunday newspapers to boost their circulation. That's made clear at paragraph 1 of the report on page 495. There are a number of issues in the case, but thankfully for present purposes we only need to focus on one issue, which is the issue the court addresses first. And the question is, were the supplies to the mail of the vouchers, so when the mail brought the vouchers in to give away, were they cost components of their taxable supplies? If I could invite
Right, when
excuse me,
get it down, when bought the vouchers
to give away, were they cost components of the taxable supplies?
Yep.
And if I could invite the court to turn to pages 501 to 502 of the judgment of Lord Justice Patton, at paragraph 29 at the bottom of page 501. And paragraph 30 as well. And so clearly, if our inputs were used exclusively for the free drinks, there would be no input tax recovery. And if the free drinks had been solely for their own sake, then the input tax on that related to those wouldn't get into the standard method calculation. It would, in fact, be unlikely that it was business entertainment if there was no purpose for the free drinks other than free drinks. We'd be in the different rules in section 24 sub 5. Likely. And turning on in the case after paragraph 31, where his lordship sets out the purpose of Article 168, the Crown's case is set out in the second half of paragraph 32. So the Associated Newspapers had succeeded in persuading the FTT that the vouchers were attributable, for the purposes of Article 168, to its business of supplying newspapers and the advertising they contain. The voucher promotions were designed to and succeeded in boosting the circulation of its titles. But HMRC's case is that this takes no account, or no adequate account, of the existence of the supplies of services constituted by the free distribution of the vouchers. Since this provides the most direct and obvious link with the purchase of the vouchers, it is not legally necessary or possible to look beyond them to the supplies of to the supplies of newspapers, or more generally the taxable business of A&L. And I emphasise that the Revenue's case there was it wasn't possible to look beyond the free distribution of vouchers, because as you may have seen in the Crown skeleton in this case, their case here is that you can't look through the free drinks to the purpose of their free drinks, at paragraph 49 of their skeleton. After discussing the various authorities in the following paragraphs, his lordship summarises them at paragraph 47 on page 509. before applying it at paragraph 48. And if I could invite the court to read paragraph 48, paragraph 49, which sets out the Upper Tribunal's summary and application of the cases, and paragraph 50, which is his lordship's approval of the Upper Tribunal's application.
Okay, we'll do that.
Thank you. And so the mere fact that you're buying something to give it away for free doesn't mean that there isn't a connection with the business that you're trying to promote by giving it away for free. That's the short proposition I want to take from the case.
Okay, I mean, there's a lot of case law underneath this case.
Yes.
But it's not a business entertainment case, is it?
No, it's not.
Not an Article 5 case.
It's not.
So we're wading into some very deep, happy for me, but deep VAT waters, when actually the real issue for us is just the Article 5 point. What does it mean?
It is the Article 5 point, what does it mean, my lady? But the Upper Tribunal put it in the terms that giving something away or using it for business entertainment means that it's not used for the purposes of a taxable or exempt business.
Are you saying that's wrong because we look at cases like this, which are in a different context?
I do say that's wrong because the fact that you're giving something away, even if it itself might not be part of your economic activities, as in the case of giving away a voucher, doesn't mean that you necessarily don't look through it to the case where you're trying to further a particular business. And to turn briefly to Thorn EMI, which is in the first volume of authority, tab 5. This was a business entertainment case.
Aha, the pavilions.
The pavilions, precisely. And this case is relied on by my learned friend in relation to some comments by Lord Justice Hobhouse about the extent to which business entertainment is not a business purpose. And so I'd like to show you those comments in their context, and also to show you the comments of Lord Justice Millett, which on our case are the ones that tell you the domestic position, and which very much show it is a business purpose. And so, as I mentioned, they're about the pavilions or the chalets at Farnborough Air Show and so on, built by Thorny EMI, both mainly for business entertainment, but also with some non-negligible use for meetings, etc. And could the company have a partial credit for the inputs they suffered on building those? Or did any use for business entertainment purposes disqualify the whole amount? And it was held by the Court of Appeal that the right to an apportionment had to be read in. There were two judgments, one by Lord Justice Millett, which very much focused on the domestic legislation, and a second by Lord Justice Hobhouse, which is much shorter and focuses on the EU Code. His Lord Justice Stuart Smith then agrees with both judgments. And in order to show that his Lordship Lord Justice Millett viewed use for business entertainment as a subset of business use, I need to take you to a couple of features of his judgment. I was going to leave Lord Justice Hobhouse's comments until I dealt with the Revenue's EU law points, but now that argument's not being maintained, I'll touch on that judgment briefly here, also to show that what his lordship is doing there is talking about an EU law point rather than a domestic UK position. Turning to Lord Justice Millett, and these are merely by way of example, first of all, the description of business entertainment as being part of a business purpose can be seen at page 194, 676D, just at the little d. The question is whether, in the case of an indivisible supply of goods or services used or to be used both for business entertainment and to a measurable extent for other business purposes, the company is entitled to a partial credit based on an apportionment between the entertainment and the other business uses. And there are a number of other examples in his judgment where he again refers to business entertainment being one of business reasons and talks about other non-entertainment business reasons. But if I might take the court to the core of his reasoning at page 197, where after having rejected the reason why the High Court in that case had read in an apportionment, he then comes to the conclusion that a provision for apportionment between entertainment and non-entertainment use must be applied into Article 9.1, the predecessor to our Article 5. And he sets out 4 numbered reasons. And it's the second one that I'd like to invite the court to read. And what his Lordship Lord Justice Millett is doing is drawing an analogy between business entertainment use and non-business entertainment use. Sorry, non-business use.
Yeah. So this is all about business, non-business apportionment, isn't it?
Precisely, my lady. And what I'm going to it for is to show that business entertainment is something different to non-business. So that a business, non-business type answer isn't the answer you get to. It's a business entertainment, non-business entertainment answer that you get to. And so the fact that he draws an analogy between the two shows that they are different things. They are analogous, they are not the same.
Okay, but so what we're looking at here is Lord Justice Millett, I think we're on.
Yes.
So you can't treat business entertainment inputs less favourably than tax incurred for non-business purposes.
Yes.
Because that would be an odd thing to do.
Precisely.
Doesn't? Yeah. Okay. I mean, I've got what he says.
Because business entertainment is a subset of business.
Well, he doesn't quite say that. Maybe he means that.
That may be the reason why it's odd.
Okay, so where do we go next with him? Does he answer the particular question in this case?
He's not asked a particular question in this
So
case.
that's as much as we get out of it.
That's as much as we get out of my Lord Justice Millett's case. As I say, this case is in the bundle because of the comments of Lord Justice Hobhouse, but I wanted to set the context for the fact that Lord Justice Millett is seeing it as a subset of business use. And so Lord Justice Hobhouse's judgment starts at the bottom of that page. And as you'll see, he says his reasons are substantially the same as Lord Justice Millett, but with a different emphasis. And then he sets out that the dominant legislation is the 6th Directive. And at little a under 680A, he says, the effect, therefore, is that expenditure on entertainment is not to be treated as business expenditure, and that value-added tax is accordingly not to be deductible on expenditure on entertainment. And he then goes on to say that it's necessary to apply Article 17 sub 2 so as to give effect to paragraph 6. I ought to show you what paragraph 6 and paragraph sub 2 are. I can show you those at page 195 and 196 of the report.
Those are old versions of things we've already looked at.
They are. I don't think you've looked at Article 176 of the VAT Directive, which is what sub 6 is the equivalent of. And Article 176 of the VAT Directive was the foundation of my learned friend's EU law case, which is no longer being maintained. But they are in equivalent terms. And so what I'm taking you to Lord Justice Hobhouse's case, judgment to say, is that he is looking at it from an EU law prism and saying what the EU law effect of Article 17 sub 6 is. Which is that expenditure on entertainment is not to be treated as business expenditure. And the short point then is that the passage that my learned friend relies on in the sidelined part of C to D of 198 is again merely a statement of the EU law position rather than seeking to construe the UK domestic legislation and say that for domestic purposes it is not a form of business expenditure. And to make good that it's purely an EU law point that he's making, at the end of his judgment, but Article 17, i.e. of the 6th Directive, and what I have said about it, also informs and provides the context for the interpretation and application of the UK legislation. This leads to the same conclusion and further supports the reasoning of Lord Justice Millett. And then Lord Justice Stuart Smith agrees with both of them. And so the submission I'd make is that given that the Crown is not maintaining its EU law arguments, I submit that Lord Justice Hobhouse's comments tell us nothing about the domestic position. For completeness, even if there were an EU law obligation to block the recovery, the UK fulfills those obligations by means of the mechanism of the block that we have already looked at, and so there'd be no need to interfere. And so I say that the logic of the Upper Tribunal's reasoning that supplies made for the purposes of business entertainment are not used for the purposes of a taxable or exempt business is wrong. Insofar as they are business entertainment, they are used for the purposes of their business. And in this current case, it's taxable and exempt supplies, but predominantly it's exempt supplies. Turning back to the Upper Tribunal's judgment at page 130, the Upper Tribunal sought to support their reasoning by reference to an example that the Crown provided. The example is that you have £30,000 in VAT incurred in capital expenditure on a building. The building is used in a particular year for the purposes of making taxable supplies of 1,000, exempt supplies of 1,000, and gratuitously provided business entertainment valued at 1,000. And the way that the Upper Tribunal says that the two approaches would apply is that the revenues approach would apply an initial block of 33% to restrict the free business entertainment use, I think that must be. The residual 20,000 would then fall to be apportioned between taxable and exempt supplies under the standard method, with the result that £10,000 of the VAT would be apportioned to taxable supplies, and this then gives a result of 33%. They, however, say that under the appellant's approach, the recovery percentage would be 50%, and say that is plainly contrary to its actual use. 50% of it has not been for taxable supplies, only 33% of it was. And they describe our approach as having the effect of ignoring the use for business entertainment entirely, and in effect renders the input tax order nugatory in any partial exemption situation. And there are a number of problems with this passage. The first is that the example is, with respect, flawed, as we submit in our skeleton at paragraph 65. It falls into the same flaw as the Upper Tribunal's reasoning in the previous paragraph. It treats the use of the building to provide business entertainment, i.e., by its very nature, entertainment to support and further the taxpayer's exempt or taxable or both businesses, as something different from the use to make taxable or exempt supplies. So it's wrong to treat that third thousand as anything separate. Secondly, the Upper Tribunal states that our approach has the effect of ignoring the use for business entertainment. But with respect, that fundamentally misunderstands our case. Our approach does apply a restriction for business entertainment, but only after the standard method has removed the use of the overheads for exempt use, including the use of the overheads for business entertainment to further that exempt use. And there is then a restriction for the degree of business entertainment used for taxable business. And it's that amount that falls to be removed under the order. So our business entertainment is different to the dispute about free vouchers in the mail, because despite having a direct and immediate link with taxable supplies, that wouldn't mean it's recoverable in full to the degree of that link, because the business entertainment block is then engaged. And it's engaged at that stage. And turning back to the Crown skeleton at paragraph 48, page 45 of the core bundle, they make the same misunderstanding of our case. If I could ask the court to briefly read paragraph 48. It's the same example again, but I need to make a point on the last couple of sentences. it's not our case that the business entertainment that there is nothing for the block to bite on. Rather, the business entertainment precisely applies to the £15,000 to the extent that that business entertainment was in respect of taxable supplies. So because the £15,000 is in respect of taxable supplies, that's why it's the amount that the business entertainment block needs to be considered in relation to. Because what the hypothetical business is doing is making supplies of £2,000. £1,000 worth of taxable business and £1,000 of exempt business. And it's right, therefore, that the starting point is that half of its inputs used to make those supplies are recoverable. Business entertainment has been used to further the taxable and exempt businesses, and it's the premise of the standard method that it measures the extent to which the inputs are used to make taxable supplies. From that measured extent, we can then restrict the relevant proportion of business entertainment. As I've already submitted, we have to do an apportionment, but there's no problem without that. And in the present case, we have findings about the level of the extent to which the business entertainment is used for exempt business. And therefore, only a small proportion of any business entertainment made it through the standard method and falls to be disallowed. Paragraph 49 of HMRC's skeleton criticise our response as saying that the only response to the point is to look through the immediate use to the purpose to which the business expenditure is being used. And it asserts that it's wrong to look through it. As we've already submitted, that assertion doesn't stand up, particularly in the light of associated newspapers. In the second half of that paragraph, they support that analysis on the basis that if our construction were right, there would be no need for the block. However, we say with respect, the Crown have this backwards, and that the critical flaw in what the Crown has to say is the first parenthesis in the sentence. The one that says, and Article 5 would not apply. Because it is precisely HCL's case that to the extent that the business entertainment is used to support taxable business, it needs to be blocked under Article 5. It is in fact the Crown's and the Upper Tribunal's analysis which would render Article 5 unnecessary. Because if inputs used for business entertainment were by virtue of that fact neither used for taxable or exempt business, there would be no need for Article 5 because they wouldn't have got through anything else before you got there. They wouldn't even be input tax in Section 24(1). On a hypothesis that use for business entertainment was something distinct from business use, then to the extent that inputs were used for both business and business entertainment purposes, as in our case, we would be in Section 24(5), business, non-business type apportionments, rather than the input tax block. And similarly, if it were because they weren't used for the purposes of a taxable or exempt business, with a reason why supplies used for business entertainment couldn't be recovered as input tax, so if that was how it was engaged, the corresponding relief from output tax that we looked at in Article 5(2) wouldn't apply, because that only applies where, by reason of the operation of paragraph sub 1, no input tax has been claimed.
Now, we're just going up to 1:30. I assume you're really there.
I am very much nearly there. I have about a page to go.
And I'm afraid I'm not going to allow you another page because Mr. Donmall definitely needs to start at the beginning of tomorrow morning. So you have 2 minutes.
Thank you. I think that's going to be hopefully less than a page. That is other way
More than
around.
a page.
The UK could, of course, picked another mechanism to restrict business entertainment. They could, for example, have provided that tax on supplies used to provide business entertainment was not input tax, or deemed that it wasn't used for the purposes of a business. And we've looked at 24 sub 5A on page 93, which deemed private use not to be for the purpose of a business. And then my very final point on the domestic law, and I really submit that not much weight can be put on it, but simply for your note, it's notable that the VAT Tribunal in Asplin, the decision that we've gone to earlier, in summarising the correspondence between the parties that led up to the dispute, described the effect of the block in a way that's consistent with our case and inconsistent with the revenues case at paragraph 24. That's tab 7, page 213 for your note. It had failed to recognise and exclude any other amounts of unrecoverable VAT directly or indirectly attributable to business entertainment, in respect of which credit otherwise allowable is blocked. Now, clearly the mechanism wasn't in dispute. The tribunal may be simply reflecting a letter written by Customs and Excise at that point, but for the extent that it's worth anything, it's there. And as such, unless I can assist the court further, those are my submissions on the input tax block.
Thank you very much. I don't know whether you were warned at one stage that we might not start before 11 o'clock. Circumstances have changed, so unless it presents any of you with any difficulty, we'll start at 10:30.
What, right,